So it basically, when an incident happens, it can range between having an authority in place that's got full authority and deals with that very, very well, to basically having very little input at all. Now, to give you an idea of the of how, at one end of the scale, talk about the UK SOSREP. So we had a couple of incidents in the UK back in the 90s. The Erica, sorry, the Brea, and the Sea Empress, and there was an inquiry after that. So Lord Donaldson undertook an inquiry, and then came up with recommendations about how things could have been done better in the UK, what lessons learned, etc. And the result of that was that one of the main things they identified was there are too many people involved in dealing with the incident, too many decision makers. So you've got the police, you've got the fire brigade, you've got local authorities, you've got the harbour master, etc. So you've got all these different people. Who is it that's actually in overall control? And then trying to make decisions is very difficult. So if you're trying to make a decision on, what action to take, you can't do that by committee in a salvage situation. You need very much to have very clear line of authority. Somebody's got to be making the decisions. And this is something that was highlighted in the Donaldson report. And one of the things they said was, okay, we think there needs to be a UK SOSREP. And that's basically the Secretary of State's representative. And so in the UK now, you have one person who's in charge, and they outrank absolutely everybody. So it could be the police, the fire brigade, the harbour master, local authorities, MPs, government, absolutely anybody. They outrank them. So they can give instructions about what to do. They can say basically, okay, they can make exclusion zones. They can tell government authorities to do things. They can tell the vessel's masters to do things. So in the case of the Napoli, that vessel was grounded, and it's widely believed and recognised that that action of the SOSREP and taking that decision to ground that vessel saved a much worse pollution incident than would otherwise have occurred. So I think basically that works very well in the UK, and it's something that's really improved the response in the UK. So what do you get? The trouble is here, not many incidents occur in the UK. So what happens when it occurs somebody else? Well, the reality is the government intervention will fall somewhere on that line. And quite often, just simple things like, for example, getting visas or getting the permission to bring equipment in is very difficult. And you can wait around for days, for weeks, trying to get just a visa to get some equipment in or to get some salvage in. And that can actually scupper your entire salvage operation. So, you might think, oh, okay, surely they're going to give us some preferential treatment given that what's happened. And it doesn't always happen, because quite often, depending on what jurisdiction you're in, there'll be very bureaucratic procedures in place, and people won't be willing to do anything without following the correct procedure. So that's when it becomes really important to have a good salvage consultant helping you, and also the P&I consultants as well, and their local correspondents who have contacts in the area. They know the right people, they know who to contact, and they can pull some strings basically and help to get these very simple things done, which allow you to get on with the salvage operation and potentially save. On that side as well, so you'll also have lawyers causing problems as well. So you can have lawyers that will be trying to negotiate the contracts. We're going to talk a little bit about LOF and how that's used, but essentially there are contracts in place that allow the parties to just sign them and have the argument later about how much it's going to cost. But in recent times, that isn't used as much, and people are trying to negotiate. So you'll have lawyers for both sides trying to negotiate bespoke agreements, and then that just causes delays. And so that also, in the case of the SOSREP, they'd be able to say, no, I'm telling you, you're going to do this. I don't care. You're going to sign. You can even say sign this contract, or like if a contract's been signed, they can say no, that doesn't count. So that's where you generally end up. You generally end up where you've got various government departments involved. You've got people with their own agendas. You've maybe even got bribery issues going on, and you can have situations where you'll be sat down for hours or days outside an office waiting to see the right official, and they won't see you. They come back next week, and the whole time the situation is getting worse and worse and worse. So that can be the reality, and the only way around that in many jurisdictions is to get the right people ground, people who've got the contacts and can get things moving. So in terms of jurisdiction and the claims, so as opposed to the incident who deals with the actual incident, the actual claims themselves will have charter parties that have bills of lading. Charter parties generally will have clauses in them with the jurisdiction, and that's not necessarily a problem. Bills of lading, they'll have clauses in there as well, which may say English law and jurisdiction, but that might not help you. For example, if the vessel's going to China and delivering cargo in China, then China will probably accept jurisdiction regardless of what the bill of lading says. So you have problems there. That all feeds into limitation. The ship owner can limit their liability under one of the various conventions by setting up a limitation fund in a particular country. But it gets very complicated. You have to have a basis on which to actually commence that limitation proceedings in that country. And that doesn't necessarily stop other proceedings being commenced in other countries. Because you have various main conventions, but some countries have ratified some have ratified others, and other countries have their own kind of take on it, very similar but quite different. So you can end up with multiple limitation proceedings going on. And limitation and liability get dealt with separately. So you can have an argument over where limitation and which court would have jurisdiction, which country would have jurisdiction, and then a separate one for the claim. So, for example, you might decide a cargo claim under the bill of lading, and then that will get put into the fund, and that may be decided in a different country, but they'll use the cargo claim to decide the actual claim itself. So in terms of investigation and evidence, this is somewhat more hybrid. The initial investigation is going to be under the jurisdiction of pretty much wherever the vessel is, and the people coming on board. And from the master and the crew's point of view, it can be really quite traumatic. They've already probably gone through a very traumatic incident, maybe not had very much sleep. They'll be being interviewed by various local authorities, put under pressure, maybe without translation services, maybe being forced to sign documents in a different language that they don't understand. And so they can have a very, very difficult time. So one of our jobs is that, as the lawyers involved, is to try and get somebody out there, but also to get really good local law, legal advice, and presence that can actually go out there and try and help them. And depending on where you are, you might be entitled, for example, in the UK, you are entitled to have somebody there, you're entitled to have a lawyer there. If you're interfering with the proceedings, then they can ask you to leave. But again, this is why you need really good local law advice, so you know exactly what their rights are and how you can go out there and best protect them. You've also got to get the balance right between protecting them, but then interfering with the investigation. Sometimes you'll see it where the owners want to actually get the crew out of there, maybe even remove the documents from the vessel. But I think you have to realise that an incident, maybe a serious incident, has occurred in a jurisdiction, and that has to be investigated. That has to, there are legitimate concerns and legitimate investigations that have to be undertaken, and it's just a question of how fair is that going to be on the people involved. So from an evidential point of view, once these interviews are undertaken, generally you can have things out in the open that can cause you problems later on that you don't necessarily want out there. And the master or the crew involved may actually say something that, with a benefit of hindsight, they probably might not have said. And when it comes down to what was the actual cause of the incident, I mean, it can take months of investigation in various different disciplines to work out exactly what on earth happened. And yet, the master's been asked to say straight away exactly what the cause was, etc. So you need to be careful there. The MOAB in the UK is the main investigation branch, so the Marine Accident Investigation Branch. And in the UK, for example, they outrank the police. They can come on board, they can seize everything, they can force you to go to interviews. And as I say, you do have a right to be represented. And also, they'll produce a report, and the idea is not to apportion blame, but the idea is to say, okay, well, what was the cause? What can we do to prevent it happening again? So they do apportion blame. But that's not the purpose of it. The purpose is to work out what's happened and then to stop it happening again. And in the UK court proceedings, you can't use that. So there could be a report out there saying terrible, judgment, but or terrible decision, but that can't then be used. And you quite often see them slipped into disclosure, but the reality is that they're not allowed to be used in evidence. So again, if you're looking at a particular jurisdiction, that's where you need really good local law advice to work out, okay, who's coming on board, what powers have they got, what rights has the crew got, and what's the actual outcome of this report? Is it something that they can use or not? And then we have privilege. So under English law, which a lot of the documents for the charged parties and potentially the bills of lading will be under English law. If something is produced with the purpose of litigation in mind, primary purpose of litigation, then it attracts legal privilege. So you don't have to show that to the other side. So that just remains between you. But the problem is if there has been a local investigation, and if it's an inquisitorial process whereby, say for example, France, they'll send somebody on board, and their job is the government will send them on board. Their job is to investigate and to determine what the cause was. So that won't be privileged. That will just come out, and you'll be stuck with what over those say.
So, hi, can I ask a question?
Yes, sure.
Yeah, please. Can you pass this on?
NAID's report is not valid in a court of law. Did I understand that correct?
It can't be used as evidence.
Then what's the point?
To prevent accidents happening again. So it's the idea is what lessons can be learned and what can we do to prevent these accidents happen. So there may be, for example, in a port, if you're going into an unsafe port, the vessel goes aground on a wall. It's undisclosed. You can't see it on the charts. The lesson learned would be right. We need to actually put that on the charts.
Yeah, sure. I understand that, of course. Yeah, but it should be like more or less. It should be a win-win situation in the sense, of course, it's to learn what not to do, not repeat the same mistake. But also, if they're taking the efforts of going into an investigation, then why should their report not be admissible in a court of law?
Yeah, it just isn't. So I think the idea is the thinking behind it is there will be an investigation. All the rules of evidence, the rules of the courts will apply, and that will decide what can and can't be put in. But as far as the MAIB is concerned, they just want you to be completely open with them, tell you everything, even what you think might have been a problem, and then people feel more relaxed about telling you because it's not going to be held against them later on. Sure.
Just a minute.
It's a collision case, and yes, we should supply reports. I mean, we used to give our reports, all the reports to the NAIB, but the opposition lawyers, they used it to their advantage.
Yes. Yeah.
And can they?
Well, I mean,
they did actually.
Yes, and you have to that's basically something that your lawyers need to pick up. So when that's put into the bundles in the arbitration or in court, they need to see that that's in there, and then they need to realise that that's actually inadmissible, and they can require that to be taken out. But people do try and slip them in because quite often they get through. Yes. Yes. Yeah. As I say, if it's English proceedings, then you could stop them. But again, there's nothing to stop that being used in foreign proceedings somewhere else. Yeah. So it really, somebody should have recognised that and got that removed.
You're doing well, Alex. You already invoked a lot of questions. You're doing well. Carry on.
And then that feeds into exactly what you're saying there with the ISM reporting system, because the purpose of ISM is to basically safety, is to make sure that you understand what happened, lessons learned, preventing it from happening again. But that is something that can cause you a problem because ultimately you have to do a report about what happened, what the cause was, etc. And then because the primary purpose is not for litigation, it's for your ISM procedure, that becomes disclosable. So it is something that sometimes you might want to say, well, okay, it's currently being investigated. We'll wait till the investigation's finished before we actually fill out our ISM in relation to that. But that's something that will become disclosable and could be used. And then also high machinery reports as well. So you need to be a little bit careful there because you'll have quite often a surveyor will go out on the basis for the whole machinery, but then someone might go out for P&I as well. P&I is pretty much certainly for the basis of litigation and therefore attracts privilege. Hull and machinery, not necessarily is the case, because really the purpose of that is to see whether or not you're going to get paid out under your hull and machinery policy. And so the primary purpose is not for litigation. So that's something that can cause a problem for you later on, and also that will quite often be attached to a GA report. So we'll talk about it later on. So again, whatever the person who goes out on behalf of hull and machinery says can become public, and then you'll be stuck with what they say as well. So there's lots of different things you have to kind of keep in mind when you're actually dealing with the early shenanigans that are going on. How can you kind of help yourself as a shipping company? Well, you have to have an emergency response plan, and as a subset of that, you really need to have a media response plan as well. So media response plan would be there's specialist companies that can help you with that, but the main point there is that there should really be one person or a team of people who are charged with that and have training, and then run over their training maybe once a year. And basics are that anything you say should be accurate and based on facts, and don't mislead, because people will accept accidents happen, but they don't accept it if you try and hide something or try and be a bit tricky. So, but it's obviously a lot more complicated area than that. And you want to get somebody in that's a real expert in that and can help you from the beginning. The emergency response plan is something that every shipping company should have as well. In reality, you're probably going to get P&I club, hull and machinery insurers, brokers and lawyers involved initially, and then they'll help you with getting your salvage team together, local legal support, and local agents, because as we were talking about earlier, it's very important to get that really good help locally with the connections and who understand the system and get the advice locally. So your emergency response plan should cover that, and it should be practiced as well. And also you need to think about the allocation of internal resources, because when an incident happens, then it takes up a tremendous amount of time. If it's a really serious incident, then you're going to be in your company, there's going to be somebody dealing with that 24 hours a day, for a number of weeks, months. And then the problem is you need to have in place a team that can actually deal with that. One person can't do that. They're going to get tired. They're going to make mistakes. They're going to make bad decisions. So in the same way as with your salvage team, you'll make sure that you've got like shifts of salvage teams involved, of people taking over. You also spread it so that you've got people going to meetings. So there'll be constant meetings going on with local authorities, etc. You don't want your salvage people tied up with them. So you want a person from salvage going to that meeting, and a representative from owners maybe going to that meeting. But then someone else stays on site, gets on with the job, and so you actually have a team of people. But the same thing has to happen in your office. You can't have one person dealing with the whole incident. You need a team in place, and that should all be in your plan. So how does salvage work? So ship going from A to B. This is a ship incident I dealt with many years ago now. This is the Hyundai Fortune, went on fire. Salvors come and help. How do they get paid? So on what basis? There's two ways. First of all, you've got under the general law, under the Salvage Convention. So Salvage Convention has been ratified by most maritime nations. Notable exceptions would be America. But many of the maritime nations do have Salvage Convention or something similar. And if you don't have an agreement in place, then Salvage Convention steps in and says, well, if you go out and help somebody, then you're entitled to an award for doing that. And so the idea is to encourage people to go out and to help vessels in distress, and also to encourage them to be ready to do that, to go out to help them. So they'll, if they've got more equipment, they've got better training, all that sort of thing, then they're going to get a higher award than somebody else, and all of the basis of that. So that's decided under Article 13. The other way is by contract. So the convention does allow you to contract out, which means you're allowed to do things like LOF. And LOF is the standard contract, so we're going to talk about that in a minute. So in terms of the general law, so on this red section here, how does it work under the convention if you don't have LOF in place and you don't have an agreement in place? How does it work? Well, generally, there's three things that need to be satisfied. So it needs to be voluntary, so you can't be under a pre-existing duty to help anyway. So if it's a local port authority and part of your duty is to help tow vessels that are in distress or have lost power, etc., then you can't claim a salvage award for doing that because you're under an obligation to do it. If you go beyond what you're required to do, then you could. It just depends what you've done. There must be danger, that must be real, or there must be a real apprehension of danger. So there can be a lot of arguments over whether or not there's danger if you try and go under the actual convention. And then success. Success. So otherwise known as no cure, no pay. So the salvor is going to get paid out of the lump of money that they saved. So they will save value of the ship, value of the cargo, value of the bunkers, and that a sum of money out of which they can have their award paid. So if there's only 100,000 there, that's the maximum they could ever get paid out for doing it. And they might have spent millions going out there trying to help them to solve the situation. So that can be a problem. The reality is that the most you'll see generally is 50%, and then there have been cases where it's been 80%, but that's very, very rare. So Article 13 under the Convention, that gives you the criteria. And the first part says with a view to encouraging salvage operations. And then you've got all these lists of different things. And the idea is that court or arbitration will look at that, look at the various things, salvage value, how much of property have you saved. So that gives you the fund that you can be paid out of. Have you minimised damage to the environment? Have you had success? Have you done a good job? Was it very dangerous? Skill and effort of the salvors, the availability and use of vessels and other equipment. So if you're a professional salvor, you're going to get a bigger reward than if you're just happened to be in the area and you went over and helped. And then the state of readiness, again, if you're a professional salvor, you'll get an award. So what will happen is that the court or the judge or the arbitration will look at that and basically come up with a figure from that as to how much they're going to get paid. And it's very interesting when quite often what you'll do a round robin and you'll send around all of the information about the incident and then get everybody to say how much they think the award will be. And you end up with massively different scales. And people that have been doing it for years, you get very different results. So it's very, very difficult to say exactly how much they'll get. That said, the awards from Lloyd's are now available online. And so it is actually, if you can go find a more recent decision, that tells you how much they got, and it was very similar circumstances, then you get a good indication what the salvage award would be. Article 14 is important as well because this deals with that situation where we're saying if it's a low value, if that fund out of which you can get paid is too low, then why would a salvor go and help? They're not going to go and help a vessel that's loaded with oil, is old and is perhaps in poor condition. So Article 14 was brought in to try and help that situation. So even if you weren't successful, there was an exception to that no cure, no pay basis. And what it said basically is if you were successful, you could get an uplift of up to 100% on your out-of-pocket expenses. So whatever you spend trying to save the vessel, if you've got some success, you can get up to 100%. Actually say something like you can get up to 30%, but in exceptional circumstances up to 100%. And that's actually quite an interesting. It just shows that this was a compromise. When you're trying to get a convention together, you can't get everybody to agree. And so, you end up with these things that actually makes no sense. You can get up to 100%, but the convention says you get 30 or up to 100. So that had problems, though. Basically, first of all, it said, well, what was the fair rate for the equipment that you've used? And there's a case with the Nagasaki Spirit that went to the House of Lords, and they said basically that doesn't have any element of profit in it. So it's just purely what it cost you, basically. Salvors were not very happy with that. And then also, there had to be threat and damage to the environment. And that meant substantial damage. So you think, lawyers, that's great. What does substantial mean? And then also in coastal or inland waters or areas adjacent there too. So if you're like 1 or 2 miles off of shore, that's going to be threatening damage to the coast. What about if you're 50? What about if you're 100 miles off? What point are you no longer threatening damage to the environment? And that's why it didn't gain much favour with salvors and then didn't work as well as it could. That got replaced by something called Stop It, which again Sora will talk about.
Thank you very much, Alex. Put a hand together for him. What he hasn't mentioned is he's a naval architect and a trained surveyor was with the Lloyd's Register of Shipping. So you've done all the hard work, mate. Well done. So let's hear what you have to say now. Thank you very much.
Okay, thank you. Thank you to everyone for coming today, despite the unprecedented flood recently, and there's road conditions that are not necessarily that great. But we're really happy to be here, and we thank Captain Urani for organizing today. And I will quickly whiz through the contracts and what happens under the LOF. Most of you would have. Many of you have dealt with LOF already, but essentially LOF is a specialist salvage contract, and it is there's a lot of advantages to using LOF. First of all, it's a really simple contract. There's only sort of the main part of it. It's only 2 pages long, although it does incorporate the LSSA clauses as well as procedural rules. It also admits danger. So what Alex was talking about previously about how the parties would argue about whether there was a danger or apprehension of danger, that's sort of out of the question because you admit danger once you sign an LOF. Law and jurisdiction is also agreed at the outset, so that's really helpful. Article 13 basis awards. So essentially, you don't have to negotiate the price. You can go, as a salvo, you can go and deal with the situation at hand. That's what's more important, and all the sort of payment terms can be sorted out by the Lloyd's panel of arbitrators. So that's probably one of the biggest benefit of LOF. In terms of SCOPIC, so SCOPIC stands for Special Compensation P&I Clause, and that was essentially an industry solution brought in together by the IG groups to deal with the shortcomings of Article 14. Again, I think Alex was basically mentioning all the problems with Article 14, and you would be arguing about how far inland coastal water that we're talking about, etc. So that sort of thing just goes out the window. As long as it's incorporated into the LOF, then it replaces Article 14. One of the other feature is that if, in terms of SCOPIC, is that once even if it is incorporated, it actually needs to be invoked before the remuneration will kick in. Security in the US dollar 3 million has to be given to the salvos within 2 days from the date of the request. And essentially, how you calculate SCOPIC is it's like a taximeter. You're on a tariff for all the personnel, craft, and equipment that you bring in, plus uplift of 25%. There's also a deterrence element, so in order to make sure that salvos doesn't always invoke SCOPIC, where Article 13 awards would have been adequate. So I'll look at that in a little bit more detail in this very highly technical diagram here. Essentially, Article 13 award, you calculate how much you're going to get paid under the Article 13, and that gets picked up by the hull and the cargo underwriters, essentially, the property underwriters. And the SCOPIC will, if it has been invoked, then that will be calculated as well. So anything that is above Article 13 payment, that will be paid by the owners, essentially, and that's essentially the P&I club will be picking that up. In situations where Article 13 awards would have been adequate compensation for the salvos, then essentially you shouldn't have, the position is that you shouldn't have actually invoked SCOPIC. And in those circumstances, what you do is under SCOPIC clauses, you calculate the SCOPIC as if it was invoked on the very first day, and then you get a 25% penalty in between what Article 13 award would have been, and the difference between that and the SCOPIC. So that gives you, that is I suppose, like this intensifies salvos from invoking it in every single time. These are some of the BIMCO forms that you might come across instead of LOF and using in salvage situation. Especially the tow hire is very common instead of the LOF as a basis for sort of doing a sort of more simple jobs, simple salvage jobs, and we do see that quite often, as well as some bespoke forms as well. Wreck hire, wreck stage, and wreck fix is obviously not as common because it's actually made for wreck removal contracts. But we have seen actually wreck hire being used in situations where, and we've used it as well, and in a situation where you need to do a caretaker arrangement between when it's a salvage situation turning into a wreck removal situation, and we do need to go out to the market and get a tender process going for the actual wreck removal job, and then you need to kind of move away from the LOF, and that might be a useful tool to have. One thing to mention is in relation to the rec stage, well, in relation to the wreck removal contract overall, there's been a I think it's called quantitative risk analysis matrix being used for the tender processes for the salvos. I'm sure all the salvos here would know about that. And that's been heavily criticized for not necessarily being fit for every single job, especially sort of the smaller wreck removal projects. So there's been an effort by the International Salvage Union with the market to revise the wreck removal contracts because it hasn't been amended since 2010, being the latest form and is the current form at the moment. And we're anticipating issuing of the rec stage, firstly, the rec stage contract this year. We've had a little sneak peek of that at the ISU Associate Members Day a few months ago. And essentially, it looks quite similar to the current PIMCO form. So there'll be box terms that followed by clauses. But there's been a little bit of more of a tightening of the definition section, including, for example, the work site of where the wreck is sitting. That has there's going to be an annex to that to show exactly visually what the diagram showing the area where the wreck is sitting, so everyone understands what the work site is. Another big changes is in relation to this QRA. There's going to be sort of like the scoping in the LOF contract. There's going to be a ticking exercise. You can opt in or opt out of it. So if you opt out of it, then clause 4, which is the change of method, which is always taken out anyway in these sort of salvage environment, that's going to be scrapped. If not, then those change of method along with the QRA will be reinstated. Okay, I'm going to very quickly cover general average because obviously we got Heather Robinson here who can talk about this a lot better than I can. But essentially, in any sort of general average situation, the idea of general average is essentially that all the parties to the sea adventure will contribute towards the losses and sacrifices made for the common benefit in the proportion of their self-interest. So there's obviously the ship's interest, cargo is a big one, a container is another big one given the increase in the bulk ship trades, bunkers where there's time charters involved and they own the bunkers, and also freight at risk where voyage charters are also involved will share into the GA losses. York Antwerp rules, I'm just going to quickly talk about that. It's basically sets up rules establishing how GA is to be applied in a particular GA situation. It has to be incorporated by agreement into a contract of carriages, so bills of lading and charter parties. And it is quite important for those two contracts to have the same rules applying. And sometimes you do see that there's a conflict between the two. They have been sort of updated and kept up to date in the with the shipping practice over the years, and there are 9 iterations at the moment, with the 2016 being the latest. They consist of lettered rules A to G and numbered rules 1 to 22 or 23. And if I am correct, numbered rules trump the lettered rules where there is a conflict. So lettered rules deals with all the general principles, and I understand that the number rules deal with all the particular, more detailed situations. General average security. I think this is probably the most important practical consideration when there's a GA incident, because as a ship owner, you will have a possessory lien over the cargo during the voyage. As the word says, it's a possessory lien. So as soon as you lose possession of that cargo, you no longer have that lien. And the practical difficulty is that adjustment will almost never be ready before the vessel gets to the destination to discharge cargo. There are also commercial pressures to discharge the cargo from the ship owner's perspective, as well as in certain jurisdictions, they'll just simply be forced to discharge. A lot of these cargoes are going to various different locations where it's owned by the government, and they're going to just say you're discharging it now and then. And once you lose possession, you don't have any lien on it. So it's so important to really get an adjuster on board and working on the securities immediately. This cargo normally gets released against the GA bonds and securities, and it also has the added benefit of overcoming any difficulties with finding out who actually owns the cargo, because cargo is obviously transferable goods that can be sold during the voyage. There's also one thing quickly to mention is that there is a duty on the ship owner to actually obtain GA security for the benefit of all other GA parties when there's GA losses incurred by other parties as well. Investigation and causation. So essentially, whenever there is a GA incident, obviously you will be owners and the experts will be investigating what's caused the incident. Evidence collection is paramount in terms of finding out what has happened, taking witness statements, etc. Then it comes down to contractual obligation as to whether the vessel was seaworthy at the time that she left for the voyage. Essentially, it will depend on whether you have an absolute obligation of seaworthiness or you've got, for example, the Hague Visibility Rules incorporated into your carriage contracts. So if Hague Visibility Rules are incorporated into your carriage contracts, then the absolute obligation will be reduced to something called a due diligence obligation. So that means as long as you've exercised due diligence to make the vessel seaworthy at the beginning of the voyage, then you'd be entitled to rely on the exceptions clauses within the Hague Visibility Rules to say, well, that's what I've done. But it is a non-delegable duty following the Doncaster Castle, so it's not a very light burden to meet. However, if yes.
Very relevant right now, isn't it? Because the city of Baltimore taking the owners of MV Dali court.
Yes, yeah. So
Sorry. I'm saying it's relevant because the city of Baltimore is taking the owners of MV Dali to court right now because they're claiming the vessel was not seaworthy when it left the port.
yes, I mean, there are a number of, from what I have read in the press, that there's a number of different causes that are sort of in the press as potential causes. I've seen something like it could potentially have been the bad bunkers. There's been some allegations of electrical failure and crew negligence, etc. Had it been for sort of crew negligence and they had the Hague Visibility Rules incorporated, potentially they will have to show that they've exercised due diligence and rely on one of the exceptions rules. Yeah. Thank you. So the bottom line is, though, if the vessel was unseaworthy, and so you're in a breach of contract of carriage, then that will be a defense to the owners of, so for example, cargo, containers, charters, whoever's the other GA interest in the vessel, from paying owners, paying contribution towards the GA. So this is a final slide, and just to quickly mention the Star and Taris, because it's a relatively recent decision in November 2023. Essentially, it was a decision on a Congen Bill 94 form, which essentially had the general average clause stating that it would be subject to your Antwerp Rules 94 or any modification thereof. And the market, market sort of consensus of that clause was that, well, all the subsequent modification thereof, such as the 2004 and 2016 rules, are new sets of rules as opposed to a modification of the 94 rules, and therefore always the adjustments were handled as based on the 94 rules. However, this decision changed that position, and I understand despite there having been, they've been given the leave to appeal, is not going to be appealed. And therefore, that changes position for a lot of parties. And if that is in your child party or your bills of lading, that will essentially mean that you're stuck with the 94 rule. I'm sorry, not 94, 2004 or 2016 rules. And there's also a debate as to whether 2004 rules are relevant at all for that purposes. So it's a bit of a gray area now, but one thing to remember is that now, because of this decision, there's a 1-year time bar from the issuance of a GA adjustment, and that needs to be adhered to, because prior to that, under the 94 rules, it would have been the 6 years. And also, there are some potentially less favorable position in the your Antwerp Rules 2004 for sort of the crew expenses and things like that that's been incurred at the port of refuge. So that sums up our talk, and we can now move on to the panel discussion. Unless anyone.
Thank you very much. Not many people know here, but Sora is very, very fluent with Greek, Korean, as well as you heard English. Thank you very much, Sora. You You were brilliant with your timekeeping. So was Alex, and so was Nikhil, Farad, and Leroy, my dear friend, who kept those questions. Uh, but we will reserve the questions for the panel discussion. We've got Siva, who's a salvage master. We've got Heather, who's an average adjuster, and we've got Captain Moniz, who's worked with the law firm for 5 years, has worked with an PNI club for 6 years, and now is an insurance and risk consultant. And myself as a surveyor, which I can say Alex has also been, as I mentioned. But we've got Slido coming up. I don't know why he has not put the scanner up, but we've got Slido as a questionnaire app, which you can type your questions. You can choose to be anonymous, but we would encourage you all to be brave enough to put your name against your question so that we know who's asking. And if you need further clarifications, we will ask you all to clarify. But what I will start with is an introduction, a self-introduction, and a small opening remark by each of our panelists who joined us today. Heather, ladies first, over to you.
Hi, I'm Heather Robinson. I work for Richard Hopkins. We're a firm of average adjusters and marine claims consultants. I'm a qualified fellow of the UK Association of Average Adjusters and based in Dubai for the past 6 years and continue to be. So the kind of work I'm involved in is predominantly hull machinery claims and general average and salvage cases, like the sort of major casualties that Sora and Alex have touched on.
What would we like them to ask you today?
What would you like to ask me?
What would you like them to ask you? Easy questions. What would be the?
Not necessarily.
Not necessarily. Thank you very much, Heather, for being here and volunteering your time for the Nautical Institute UAE branch. It's an appreciation that we have towards you, and we'll come back to you when we have questions. Siva.
Hi, good evening. My name is Siva. Basically, my background is I'm a master mariner and a salvage diver. So I joined I'll put it this way, I never worked on a normal ship since 1997. And I've been diving and worked my way up and being a salvage master and worked with international salvage companies, starting from Singapore and then in the Netherlands and then in the US. And 2014, started my own thing called VMAX Marine, where we provide salvage consultancy. I'm a member of the Lloyd's panel of casualty representatives. That's when they call a guy like me when they book Scopic for the underwriters. Thank you.
Thank you, Siva, and thank you for being a very vibrant committee member of the Nautical Institute, who's team lead for the seafarers' welfare. I think he's seen enough of those where seafarers have been left high and dry, so he's put his hand up for taking the lead on helping out with seafarer welfare amongst the UAE committee. Thank you very much for that. So we've got most of our team here, but we wouldn't do anything without insurance, would we? And a risk consultant. So that's where Captain Moniz comes in. And Nigel, can you please explain what you do and how you would add value to this panel?
My name is Nigel. I'm a master mariner. I've been at sea for 13 years on various types of ships. Worked with Morgan Fenwick in London and then with another fish team underwriter in London as well. And since 2017, I started my own insurance and risk consultancy, where we consult with various insurance companies, which hedge funds, with private equity, who are actively involved in ship financing with banks, as well as on their own. So we look after a lot of their insurance and risk portfolios. And I also consult with Alex and Sora at Tate McInnes on various matters on the wet and dry cases. So hopefully we'll be able to answer some of your questions, hopefully not too complex. Thank
you. He's usually more brave than that. He is used to being asked difficult questions. But you wouldn't do anything without a surveyor, would you? And surveyor who likes to be called in for large claims. So if you all haven't yet known about me, I don't know what you're doing here, but I look after the Nautical Institute as a secretary, and I love marine claims. My family loves it. My car loves it because I get fueled with it. And most of my friends do because if they know me well, they like it. So marine claims feeds us all, a lawyer, maybe a salvage adjuster, a salvage. So we hope it doesn't happen. If it happens, we feel very bad, but yet we would like to send our invoices in. That's the honest truth. That's what we write in our report, without prejudice. All right, so if you haven't yet downloaded the Slido and haven't logged in, please do so. We will start this with a bang. We will only pass the mic around because it's logistically a difficult thing to do to walk around with the mic. It uses a few seconds. So what I've been, as you can see, doing is being very lazy as a panelist and a moderator. I've let everyone introduce themselves. I've let you all type your questions up. And I've also given the liberty to the panel to choose the question they want to answer to. So here's the first question. Opportunities. What opportunities do you see for implantation of unified accident action plan, whatever that means? Who's asked that? An anonymous person. Does anyone have an answer for that? Opportunities. Yeah. Unified action plan.
I think if we are talking about this region, the UAE, where you've got 7 emirates, but when you have an incident in a specific emirates, it's not unified. So I think there is a need for us when it comes to emergency response that it should be a unified thing. I'm all for source reps. Working in the UK, I've had the experience of that, and just like in Australia, AMSA has a source rep. And here we need to have some sort of a body or an individual or a federal body that takes control of the entire UAE coast. It's quite a big coast, but they have, through my personal experience attending salvage cases, they do not have that, seem to be that general being on the same page on approaching the initial response. So that is crucial because the first steps is absolutely crucial in emergency response. Thank you.
Thank you very much, Siva. I think that answers it. And also, most flag states are supposed to report to the IMO the crew casualty investigation report, so that it comes down to it being a unified place where it is all captured. MAIB does the same. It is for most flag states sign up to MAIB, at least those who are friendly states to the UK and the MCA. But there are enough signs and symbols. There is this attempt made, but then commercial interests draw everybody in different directions. So that's the answer to that question. I think whoever asked that should be satisfied. Anuj has asked us next question. Do you think the concept of predetermined port coordination team would be helpful in case of major accidents or natural disasters? Would Alex or Sora want to take that one?
Yes, so I think this really comes down to what we were saying about the system in the UK, for example, where you've got the SOSREP and you've got one person in control. So I think it's helpful if you get more coordination. That can only help. I suspect that wouldn't be enough. Ultimately, you've got a lot of different interests. You've got a lot of different agendas that people are trying to push, and so ultimately, I think it probably needs to go a bit further than that.
Thank you very much. Anuj, does that answer your question? Thank you. I'm going to skip your next question, Anuj. I'm going to go with somebody from client call. I can't hear, I can't read very well. No, there was somebody from client call. You want to speak it out? Go on.
I think the question was about reissuing adjustments under the 2016 rules. The owners have been requesting this.
Yeah, so it's where we've had adjustments published, and sound charge came out, we say it's time barred, and suddenly certain law firms come out saying, well, actually, we'd quite like the adjusters to reissue the adjustment to clarify it's now effectively subject to the latest edition of your accountable rules, and therefore it's 1 year from the date of the republication. So how do you feel about being asked to do that?
The whole case came as quite a surprise to most marine claims practitioners, I think, because it went against everything that we practiced for the past however many years. So we always took the view that the latest set of rules were a new set of rules, and the kind of historical reason for that was because in 2004 your accountable rules were quite influenced by cargo interests who kind of pulled those through without really getting them agreed by other stakeholders. To some degree, so they're very unpopular with ship owners because it takes out allowances for things like crew wages and maintenance at a port of refuge, which is one of the, in a large GA casualty situation, can wipe out months of wages, which a ship owner would otherwise recover as a GA expense. So that's the kind of history of why I think the position that claims practitioners took was to treat the later sets as new sets of rules rather than modifications. And I think this decision has been quite unpopular with adjusters, and it's not the first time that the courts have taken a completely different line, which I'm not saying is wrong. I think legally there's probably good reasons for it, but they've done something which is in direct it's directly the opposite of what market practice and what the claims practitioners are doing. And it was the same with the Longchamp. And I mean, overall, it's rare that a GA case kind of gets to court, which I think means generally adjusters are doing a good job. Otherwise, it would be tested more. But when it does happen on a point of law gets tested and then we all get proved wrong, we have to change how we're doing things. So we, as far as I'm aware, RHL has not reissued any adjustments, as far as I'm aware. Don't quote me on that, but to the best of my knowledge, that it's not yet happened.
I don't know if it was you, but I do know an adjuster has.
It has. Yeah, I mean, there's lots of advantages for the owners in doing so. I suppose, well, at the moment the interest rates are high, so under the latest set of rules, you get US prime interest rates, which might be around 9%, whereas under the 94 rules, say you get 7% and 2% interest, 2% commission on top, and things like that. So I can see that owners might want to get them reissued but it raises a lot of difficulties for the adjuster. I mean, in terms of something like interest, do you then run interest up until the date when you reissued the adjustment, which might be 3 years after it was originally issued? So I think it raises a lot of potential difficulties for adjusters to try and navigate. And in conclusion, I don't really know the answer to this question of what the right thing to do is. I think as adjusters and members of our professional body, we kind of look to the association to give some guidance. And in the past, they've produced rules of practice, which kind of is sort of like a codification of the law around certain treatment of costs, for example, in collision cases, or the treatment of how you apportion like removal expenses and dry docking charges, where you've got kind of common works and things like that. So I think in conclusion, I hope that the association, the UK Association of Average Adjusters, will produce a report or some guidance on this to sort of support claims practitioners in what they do and making sure that there's some consistency in what we're all doing collectively as adjusting companies. So I'm not sure I really can answer the question any differently.
Thanks.
Thank you very much, Heather. That was a very comprehensive answer, I must say. The next one is seemingly something that Alex and Sarah were discussing from Captain Manish Verma, I've been told. Can ship owners really limit the liabilities in a large incident, something like what happened at the Baltimore Bridge? And if so, do they have any remedies? Would you have any unsolicited advice?
Yeah, so the position there is going to be under American law, so you would definitely want the American lawyers to answer that. So I don't know exactly what the answer is for that, but
if it was in the UK, what would it be? If it had been in the UK, would you think?
The general position, and there's the Limitation of Liability Convention, and under the latest one, 76, I think 96 with the 2012 limits coming up, And for example, cases I've dealt with recently, you're looking at somewhere sort of 30 million, 70 million, that sort of figure that you can limit your liability to. There's also the question of whether you can break limits, and it's easier under the older conventions to break limits, but under the new convention that actually gave higher limits, and it made it harder to break those limits. So in order to break through those limits, it had to be done basically either with intent, recklessly, or with intent and with the knowledge that the loss would probably result. It's very, very hard to break through those limits. So it generally can. Honestly, I don't know what the position is in relation to this particular vessel in America, because it will come down to the American law position.
We know that they have asked to have their liabilities limited, the managers and the owners. Do you think it's going to have any legs to stand on, or it's going to be thrown out?
Yeah, I mean, basically, what will happen in an incident? People will try, and depending on where the various parties are based and what various contracts are involved, they will then try and set up a fund that may be more beneficial to them in a if they're, for example, if that particular owning company is in a particular country and they have a certain liability regime, they may well try and protect themselves by setting up a fund there. That might well be enough to protect them, and it might not, because other people will be, you'll get other funds set up in other locations, because charters can also set up funds as well, and then you'll have a conflict between two, and so it gets very, very, very complicated. But as a general principle under maritime law, the idea is that you can basically limit your liability.
Thank you very much.
You
got
follow-up question to that.
Follow-up question.
In cases like this, then when the US law is applicable, then the companies, they do need to take out a separate insurance if the vessels are trading in the US, because
No, I don't know. You're the insurance consultant.
Under normal circumstances, you would have to declare the trading areas that your vessel is going to trade in. So if it's a worldwide trading, it would definitely cover the US trading area. So the P&I clubs or the hull and machinery underwriters would definitely factor that into their premium projections and also their risk matrices that they'll be using to arrive at that premium. So there will be no additional premium at the onset, unless it's, say, for example, you say you're trading only in Europe, and then you have a voyage going to the US, then you have to obviously pay an additional AP for that, provided the club, fixed premium or international group is willing to extend the cover for that voyage. Generally, there wouldn't be if you declared it right at the start.
I was going to add on the Dali case under US law, it's based on due diligence. Ethos 1 is a classic case which went in favor of the ship owner, where they would limit it to 32 million odd, where the cost was over 200 million. So that's really the fight, like you highlighted, that was the vessel in compliance and was due diligence carried out. How that is verified, that outcome will decide whether the limit of liability sits or not under US law.
Just to follow up from Anuj, I actually worked on the Athos 1. It's a very interesting case because there was, from the ship owners, the reason why it went in favor of the ship owners is because there was an anchor that was lost it hit the vessel, single hull vessel carrying a very heavy crude from Venezuela. And unfortunately for the ship owner, it hit a welding seam, which is a 1 in I think 10 million sort of probability. But I think the reason why it went in the ship owner's favor initially was because the liability was on the port and the channel and other parties involved with dredging of the port and the berth and stuff.
Does it answer your question, Captain Chopra? Thank you very much. I'm assuming it's a yes. All right, thank you very much. We go with, I'm giving priorities to people who are putting their names up. So as you can see, I've got to pick and choose. There are so many lovely questions coming up. But this next one coming in highlighted in blue is from Ravindra Singh Hunjan, and he says as a proactive measure, P&I clubs to make it mandatory for the members for a robust ERP involving all relevant stakeholders. It's just so broad and so proper. It sounds just, we all have been at sea. It's just impossible. I can answer that straight away. This is for the review by experts. What do we say? Siva, you've been quiet too long. Do you think in a perfect world this is possible?
I wish it could happen, but it's it's such a gray area. If you talk about the kinds of incidents that's happening, okay, you got pretty much your groundings, your fire cases, and the basic sort of salvage cases. But if you're going to have a robust emergency response program or procedure with relevant, your premiums are going to go up, put it this way, very, very quickly. And it's all about commercial impact. So if you want to be having a very robust emergency response plan, be it in a port or any jurisdiction, it has its commercial impact. And that's going to come down or cascade to your premiums. I give you like the Dali, for example, everybody's talking $3 billion claims, and it's going to hit the IG group. But rest assured, your premiums for your car, for your home, is all going to increase because of that. That's how it works. Thank you.
I saw Leroy's eyebrows going up to his forehead. All right, this is a fact. I must take a pause here and say to those who are online and those who don't know, they are all being recorded live. We've got the permission of the panelists, but those who have been asking questions on the mic, they'll have all been heard from those anonymous sneaky peeks who couldn't make it here. We got somebody in the audience wanting, but we'll just take a quick question which is directed straight to Sora, which has been quiet for too long. But Sora, what do you think of this answer? I'm not going to read out the questions right on top, but somebody's actually pointed one at you.
Yeah, I don't actually know the statistics. I was actually just quickly looking at the Lloyd's website because they actually publish how many cases, LOF cases they've got and how many of them have invoked Scopic, but it doesn't actually give you the percentage of cases where they shouldn't have invoked the Scopic. So yeah, I don't actually have answer to that, but in every cases where you invoke Scopic because the value of the ship is, for example, low, and you anticipate there's going to be more. You anticipate that Article 13 isn't going to be enough, but you ended up being wrong as a salvo. Unfortunately, in those cases, you will be penalized by 25% unless you're able to reach a settlement outside of that. Yeah, but I don't have answer to that question because the Lloyd's do not publish the actual statistics of that.
Thank you very much. Does that answer whoever it was that asked? We've got somebody from the audience who's not wanting, who wants to do it the old-fashioned way with a mic. Please go ahead and ask us a question.
Yeah, we have been hearing and the legalities involved in this. But what I could see there is a case of here is we are talking about the salvage operation for the ship and the cargo and the bunker on board. But there is the bridge is there, which is broken, which is now restricting the navigation. Now, have you seen, but it's not a ship. So PSI Club essentially covers the rig removal of a ship, but the bridge is a ship, but it is not, bridge is not a ship. So what do you think, who will cover the expenses if the salvage or the rig removal operator is coming and clearing that rig? Whose responsibility is it? Whether it would be the hull and machinery underwriter or
I was going to say, like, I'm not exactly sure the answer to that question, which might be better directed at you, but we had a case where an offshore vessel had damage to a crane, which fell on an offshore platform. And the question was, who's going to pay for the cost of removing the damaged crane? Because the crane at that point can't be repaired. So it's just a case of, it's a liability, really. But we were kind of looking at, well, the ship needs to be disconnected from the crane in order to go and be repaired. So to what extent, are those costs part of the reasonable cost of repairing the ship. And in that case, I think initially there was a kind of agreement drawn up between the P&I insurers and the hull insurers to just cost share until such time as they've worked out liabilities and who was going to pay what. But our opinion was, well, the vessel can go for repairs once the crane is just disconnected. So the rest of it kind of falls on the club because it's a wreck removal essentially. I think part of your question might be that, you know, as part of the salvage operations, you might have to clear some of the bridge in order for the ship to get underway and go somewhere where she can be repaired. And a lot of those expenses would probably fall within GA if you know, you've got to physically move an obstruction in order to kind of get the ship in a position where it can be towed or something along those lines. So I think part of those expenses might fall in GA, but certainly not all of them.
Yeah, I mean, generally when you have like a collision with a structure in a port, then again it comes down to the actual jurisdiction that you're in. But quite often you'll find that there's strict liability in relation to that. So, for example, in the UK, there's strict liability for any damage to port facilities, and you know, so that means that basically you are liable, and you have to pay, and there's no kind of well, I exercise due diligence or I exercise reasonable care. So again, it comes down to the local law position, but quite often it is the actual removal of and the repair of the port facility. It's all on the P&I insurance essentially.
Thank you.
Thank you very much. Can a seafarer keep quiet and say, I won't speak until my lawyer is there? Rohit, my dear batchmate from South Shields, has asked this very important question. And I can tell you this on my experience as having done a few such questionnaire of being on site when such large incidents. They mostly keep quiet. They mostly ask for direction from the superintendent. They mostly ask advice from the lawyers. Very rarely that they start singing. But they usually take this as a precaution to keep quiet and ask for legal help to be by their side. But I think Rohit's question is more so whether they can actually just keep quiet and only selectively give answers. Can they? Or have they? Do they?
Yeah, I'll give the same answer as you know, it depends on the local jurisdiction. But for example, in the UK, they changed the law there probably about 10 years, probably more than that, 20 years ago. You used to have the right to silence, and you could just be quiet. And they changed it so that if you fail, basically you had a caution that said if you fail to mention something which you later rely on in court, it can be used against you. So so again, it will depend on the local jurisdiction. If it's in the UK, the same, the MAIB have tremendous powers to go and carry out investigations and interviews. And if you were to fail to mention something that you should and you don't later on, then that could be used against you. So it's not necessarily safe just to think, oh, I've got this ability to just say nothing, and it's up to you to have to prove what the position is. And equally, as I was saying there, like the position in the UK is you are entitled to have some representation there. But if the investigating officer thinks that that's hampering their investigation, they can ask you to leave. But they only do that in quite extreme circumstances. But yeah, that's a possibility as well.
Yeah, thank you very much. Does that answer your question, Rohit?
Yeah, I get it. It's a no.
So yes, you can keep quiet, but I don't think you'll be able to keep quiet for too long. Here's an input. Okay. You're a committee member. You have the right for an input.
From a management company point of view, you know, as everybody knows, there are already some statements given there to help our colleagues on board. It's already pre-written, and you know, where they direct any calls or anything like this towards the media, our media consultants and in lawyers, basically, and that helps a lot.
Thank you. Thank you very much. That is a good input. We have one interesting question where fraudulent activities. Siva, you've been out at sea, and do you see anybody being fraudulent? And then we leave it to Nigel to talk about being a consultant.
The famous one is stuff so brillante, which you were on as well, Captain Tadi, and you wrote a book about it. The surveyor got killed. Jesus. So, I'm also of the opinion personally as a Salvo or ex-Salvo, where you get LOF cases where a tugboat is there and then you just hook up a tow and the owner signs an LOF, the salvos. And the vessel is not in danger. It's just dead in the water. They say they have a mechanical problem and we need a tug. And they said, okay, the tug operator says, yes, I'll only get that to you if you sign an LOF. And they said, fine, I'll sign an LOF. And they just tow the vessel there. And it could be a tow hire or tow con, a commercial contract. So there are cases like that. And I'm sure Alex and Sora would have their experience as well on claims and such things. So there are cases. There are a lot of cases that sometimes just, is given the ability to just slide away. But it does exist.
Yep, and from my experience and what we know from the insurance market, UAE for cargo claims and small ships collision claims is pretty notorious to have claimants expect the moon from the underwriters, and there is a bit of a be careful kind of a note when there are insurance policies in the Lloyd's market which are coming and led by the underwriters in the Middle East market, because the moment there is a claim, and we've seen so many claimants, small or large, they expect insurance companies to foolishly pay anything that they ask for. So there's a bit of a expectation that just because I'm paying a premium, I'm expecting everything out of the insurance companies to pay up, and that's something that's predominantly known in the marketplace.
I would agree with Captain Zarir on that. We see this a lot in various claims. When we look at the claims post incident, a lot of heads of claims which we were never reported at the time, they added on, which blatantly have issues with. I think that's common in certain areas in the world. I think that is something that insurers deal with on a daily basis. And I think the meeting of expectations between the assured and the insured is always a challenge, especially when you have complex claims which are patterned.
Thank you very much. Do you want to add something? Yeah, please.
We did have, when I first moved to Dubai, we had I think, fraudulent yacht claim, which was owned by an arms dealer, and he alleged that he'd been on a deep sea fishing trip in November off Istanbul, and the vessel had sunk, which obviously there's no evidence whether that happened or not, other than a WhatsApp message which he then screenshotted and sent, reportedly showing that was the location where the sinking happened, that he just so happened to have a friend nearby in a rib that he could pick him up. So there was quite a lot of documents that they provided which were just basically not legitimate. I mean, the report from the Coast Guard which they provided apparently involved 2 employees of the Turkish Coast Guard who, really sadly, but he Googled it, had actually passed away 2 years before in another incident. So we were not able to get enough documents to get over the kind of burden of proof that this had actually happened. And I think probably it was a case that it didn't. And so on balance, we just have to report to insurers that there's not sufficient evidence to show that there's a claim on policy. So kind of a decision for you whether or not you want to tell the arms dealer that you're not going to pay his claim. But he kept turning up at the insurance company's office and placing a handgun on the table and asking whether he could discuss his claim. So, I think know who you're insuring and decide whether or not you want to take that risk. It ended with me saying I've reported as far as I can, and there's a decision for you whether you want to make an ex gratia payment or not, but there isn't enough evidence to show that there's a claim on the policy, so that's our conclusion. I actually don't know. I mean, the guy at the insurance company in Turkey was really kind of in hysterics, saying change the report and issue something that says it happened, which we obviously can't really do in our professional capacity. So I just don't view it as complete commercial view of what we actually we would just take the report we produced, which was a report of the facts, left it there. But I definitely think that there's a lot of fraudulent claims, I'm sure. But there's only so much as a person investigating the claim that you can do to figure out what really happened with things like sinking cases. Because often, you know, I don't know, how do you find the evidence? It's difficult. But you've got to prove on the balance of probabilities that it happened. So you've got to prove 51% more likely than not that what they're saying happened. Yeah, I think difficult.
Do you think we should co-author a book on this subject?
Well, I don't know if you read that one, the one on Volante, but it was quite interesting.
That's a lot that we can talk about fraudulent expectations from our claimants. But Nigel has something to add to this.
I want to add that it's not only the claims that it's also during the evidentiary gathering process that there's a lot of elements or shadows of fraud that takes place. When you're gathering evidence from assured as lawyers or investigators, I think that's always a challenge when you're on board a vessel that post incident, where it's basically as the owner's lawyer or representing the owner, you have to be very careful on what evidence you're getting and the veracity of it. It's not only the claim side, but also on the initial evidentiary side as well, which is quite interesting.
Thank you very much, Nigel. Being a committee member, Captain Anuj Chopra should get a second opportunity, I think, and he's asking whether full-scale drills with all stakeholders can add value to preparedness. I mean, preparedness of an incident, a large incident. Yeah, having a mock there are, I think, enough companies who take up emergency preparedness exercise. So, do you have any examples? Do you know? Do you want to name a few of your good clients who probably your competitors listening to online? Or
I think it's exactly what Captain Irani said. I used to work for a ship owner prior to going into private practice, but they all sort of hold, crew awareness courses, full drill, that sort of thing. Probably not to the extent of, getting all the equipment out, but, there'll be a briefing, I know like some of our clients actually, for example, in Germany, they'll hold these sort of conferences with their seafarers to ensure that they are prepared in the situations like that.
Thank you very much. Alex, do you want to add?
Yeah, I think there's just a limit to what actually a company can do. As I was saying earlier, it comes down to who's in charge of the actual local jurisdiction and has the power there. Yeah, it's very good to be prepared. It's very good for reports to be prepared as well. But there is a limit to what you can do. I mean, you have companies like, for example, salvage companies will run training courses on these sorts of things, dealing with maritime emergencies, and they can be very good courses to send your people on, because that will be a residential, I think it's a 3-day course, depending on who it's with. Those are very valuable courses you can go on, and they can also help you looking at your plans and things like that. So there's a lot that everybody can do, but fundamentally you come back up against this problem, which is identified in the Lord Donaldson report, where people have their own. You have lots of different people who've got the power, too many chefs, and people have their own agendas. So it's very, very difficult to make decisions by committee when something's going wrong.
Yeah, thank you very much. I can see the barman topping up his ice bucket. I will take the last couple of questions. There are no new questions coming. I can see some thirsty faces in front of me. Sorry, I had to tell the barman not to serve drinks while our panel was speaking. Whoever was gone up there and asked for this. I'm the man to shoot. Anyway, heading on to the last one. We are a region where your sanctions can't be ignored, and sanctions question, there is no conference or panel discussion. It goes without it being asked. So, do you think GA bonds will get affected by the recent uptake of the US sanctions that tighten their screws and things? What are your views on that question out there?
Yeah, I think this is a really big problem for shipping ship owners. The short answer is, I suppose, they just need to be aware of who they're chartering their ships to, who's subchartering their ship, and making sure that there's a cargo order which is used or sanctioned, because in a nutshell, the adjuster isn't going to be able to collect security which is provided by sanctioned interests. So it will create no end of problems for a ship owner if they have an expensive day, and they might be left in a situation where actually all insurers might walk away if there's sanctioned cargo on board. So at that point, I don't think clubs will pay out in respect to casualty. Probably hull insurers won't pay out, and therefore you're left standing alone as a ship owner, which is not a good position to be in. So the sanctions issue is to be taken very seriously. And I think we have seen it becoming increasingly an issue regarding GA security, and there's not really an easy solution to that. So I think the moral is just be very careful and look into it as much as possible who you're contracting with.
Siva wants to add.
I think the biggest challenge with Russian oil or Russian cargo is the cap price. I've got friends who are running tankers, and sometimes they're taking Russian cargo. They say it's cap price, but it's not. So that's where the big gray area happens, and that's where they have problems with the underwriters or trying to get an underwriting. But because they may say, yeah, I'm trading at cap price as per the US mandates, but at the end of the day, someone is suspecting that it's not cap price, and then they have a vessel stuck with cargo but no insurance, and it becomes a real problem.
Thank you very much. One last question from Captain Sri, which is my favorite topic, which is obviously, can somebody go take the Americans for the cleaners for not having barriers around the bridge? What do you think? Would it stand good in UK courts, for example? Alex, you won't have barriers. You're going to have your bridge legs exposed.
First question about blue. Highlighted in blue.
Answer, but ultimately it comes down to the actual causation, which is obviously under investigation. So I think it's pretty clear from all of us having watched that video, the ship, the Dali hit the bridge. I don't see how they can get out of that by essentially saying the port wasn't as prepared to deal with this sort of situation. I mean, that would be sort of my rough take on it.
Yeah, I think when you look at ports, as I say, the position in England generally you'll have strict liability in relation to any damage to the facility. So that I think that's kind of the starting position. But there is some authority to say that nowadays with modern port plans that have to be in place, risk assessment. Have you undertaken your risk assessment? So then you can actually then bring a counterclaim back. To say that your basically your risk assessments weren't up to speed. So I think that's got to be tested. I don't know what the position is in the US in relation to that, but that's certainly the opposite side of the coin. So even though you've got strict liability, you have a recourse claim yourself against the port authorities for a failure to have proper risk assessments. I'm conscious we didn't talk about the Suez Canal at all and that sort of thing. You mentioned that in the
Yes, the recent report, Panama has come out with it. Give us some views on that. What do you think?
So I think my understanding, I have been through it, my understanding is I think it was caused by, it seems to be partly from problems with the pilots and partly problems with interaction with the sides of the canal. And we've seen a number of cases very similar to this in the past. Essentially what happens is you get close to the most people will know this better than I do, and Nigel will say that like fluids have to go down a smaller space to go faster, lower the pressure, and you get sucked into the bank. Sorry, you get sucked into the bank, and then there's an overcorrection in the steering. You head back over towards the other bank. Same thing happens over there. It's a bit like losing control on the on ice. So This isn't like as uncommon as you would think. I think in the position of the Ever Given, that obviously then blocked the canal, and that was the major problem. But there are issues that you see. I mean, for example, there was another case, the Panamax Alexander, where there was a 7-ship pileup in the Suez, and when you actually get involved in these sorts of cases, one of the issues is that you've got the pilots. How good are the pilots being? Are they maybe making mistakes? And in this case, I think there was arguments going on. I've seen that before in the past. I've heard the clinking of cutlery, people eating their food. So there's all sorts of things that you pick up on the VDR. So from an owner's point of view, I think really what one thing that you can do to try and prevent incidents like that happening is to increase your training for your masters and your watchkeepers in relation to going through canal areas, because generally under English law is you can't just say, oh well, the pilot failed to give us the correct instructions. The master remains in charge, and the master has to prevent that happening. There could be pressure on people to go through too fast, and so if you'll be exceeding, if you actually then dig into the regulations within the local regulations to do with the canal, you may well have been exceeding the allowable speeds down there. And once you start doing that, problems with interaction become even greater. And then, and what you actually need to do is you need to slow down. So rather than just keep trying to correct your steerage and then you're having interaction on both sides of the canal, what you really need to do is A, slow down and then not have gone so fast in the first place. I don't know whether that was the case with the Ever Given, but these sorts of incidences do happen. And I think having better training for the masters, where they take control of the situation earlier, and they're aware of the minimum, maximum speeds, etc. And then when it does go wrong, for example, in the Panamax Alexander, it's a mess, and everybody, because basically one ship stops, it can be miles away, and then all the other ships have to stop, and then they have to get tied up. There's not enough, there's not necessarily going to be enough tugs around to help you do that, and it rapidly becomes a complete mess. And if you look at the court case in relation to that, you start seeing arguments. I can't remember the exact amount, but I just remember they were talking about, should we be going 1 knot faster, because it was a very small amount where you would get steerage for that particular vessel, and that they didn't have naval architects' evidence and input because they used something called nautical assessors in the advocacy court. But when you're thinking, if I was a master on board and I have to decide I need to go 1 or 2 knots faster, I think that must be a very difficult thing to do. And then Nigel, you'll be able to speak. How easy is it to get a vessel tied up in the canal?
Alex, I think one of the most important things on the Ever Given case that people seem to have omitted is a vessel of that size. The Suez Canal Port Authorities has a mandate that it should be escorted with 2 tugs. They never did that. So, the masters of any vessel these days, you need to look at their local laws. If they don't have a tug, call for one. Don't take her in. That was the case with the Ever Given. Had she had 2 escort tugs and under high wind conditions and she's yawing around, you could easily have controlled her. But because of that oversight, the Suez Canal authorities received $935 million.
And the speed as well. She was overspeeding.
But if the master say, look, your rule says now my vessel is over 300 meters, I need 2 tugs. Where's my tug? You just ask the pilot, where's the tugs? And if you can't produce the tugs, I'm not moving. And you just let the charters know. That's the law.
And your last comments on this?
I was going to just say that, but I also was going to touch on the point of on the Dali. I've been under that bridge many times when I was sailing, and as far as I'm aware, the US doesn't have any requirements for tug escorts, especially big vessels. And I think that is definitely going to change as we go along, because I think we should do that port at least twice a month. and navigating in any river is challenging, but I think it's also the fact of having escort tugs. I think is going to become a mandatory requirement in various ports in the US now.
No, so it's there is a law, but it's decided by the port authority. For example, Savannah, the LNG vessels are 100% escorted, but equivalent size of container vessels are not escorted because it's based on a cargo risk, and that's one of the challenges. And this has been raised. So both these things, what you're saying, have actually been identified by NTSB, and they are being looked at. One is that in US, the problem is the infrastructure was built for smaller vessels, which is now being used for larger vessels. Was the bridge adapted to that and the strength or not? And second is, of course, the escort tugs. And remember, it's the container lines who negotiate this with the ports to avoid that container charge. So there is both sides argument, but just to correct this, this is being looked at. And apparently there will be some guidance coming from NTSB on this.
I'm sure it's going to come, definitely.
Closing remarks. So, Sora, anything you want to add to anything that has been talked about? We'll start with you, and we'll have a couple of sentences and then close this, as we can see a lot of heads going down in the phones.
Yeah, I think we've talked enough today. Thanks to everyone for attending, and I really hope that you will stay for a couple of more drinks with us and have a more sort of private conversation before heading off. And yeah, thank you.
Yeah, I reiterate that. Thank you very much, and thank you to everyone on the panel for helping us as well. And yeah, very good. Thank you.
Thanks for having me. And moral of the story: if you have a major casualty, appoint an adjuster.
Thank you, everyone, and I think we all are speaking to passion, and it's good to see so many passionate people here. Thank you for coming.
Thank you very much. Echo all the panel's comments. Thanks for staying a little bit later, I think, than we planned, but thanks a lot, and please join us for some drinks.
1 minute overtime, that is. We had planned it for 8:30 closure, and we have done so. Thank you very much, everyone, for coming, and please stay back and enjoy and network till dawn if you can. Thank you. The link is live on our Nautical Institute social. So if you have a colleague or your friends want to listen to this, please pass it on. Thank you.